Afternoon. My name is Behnaz Mansouri. I'm a senior attorney with the Unemployment Law Project. The Unemployment Law Project has been around since 1984. We are the only freestanding legal aid organization in the country solely dedicated to unemployment. We are here this afternoon for our weekly webinar to share with you the latest news and to provide answers to your questions as you share them in the chat box. As you know, the Unemployment Law Project provides free advice and free legal counsel to unemployed, to people seeking unemployment benefits or whose award of benefits has been denied. I want to introduce our speakers today. It will be myself and the Unemployment Law Project's Executive Director, John Tierpak. Our staff attorney and policy director, Ann Paxton, is unable to join us today since the legislature in Washington State has begun its season, and Ann is quite busy doing our policy work. She has provided us with relevant and pertinent updates, which I will share, and my colleague Erin O'Brien will be dropping all of the relevant links in our chat box today. Please drop your questions into the Q&A as we proceed, and we will answer accordingly. Also, closed captioning is available for this broadcast. The button should be on the bottom right-hand side of your screen. Let's get started. Okay. The job search requirement, which you know was suspended last March, has been suspended through the emergency. Traditionally, over the course of last year, the job search requirement was suspended on a month-to-month basis. Following Senate and House vote last week, the status is now until the pandemic state of emergency is withdrawn by the governor or legislative action has been taken, this job search requirement remains suspended. ESD Commissioner Susie Levine will be leaving ESD to join the Biden administration. Her last day at ESD will be on January 31st. And if you are not aware, Commissioner Levine did previously work in the Obama administration. And since leaving that, she has joined ESD in Washington State. The State, Senate, and House committees voted to approve SB 5061. The governor's bill, which is now at the Rules Committee and is progressing toward an eventual vote on the floor. SB 5061 allows workers at high risk of severe illness or death from the disease causing the public health emergency and workers who live with high-risk people to claim benefits during the emergency if they are available for and seeking suitable work that can be performed at their home. SB 5061 also increases the minimum benefit amount from $201 to about $270. There will also be some easing of unemployment taxes paid by employers. Over the last 2 weeks, ULP has testified in support of SB 5061. We have also testified in support of SB 5064, which is expanding the good cause reasons for a quit to include caregivers whose, when an employer changes in hours, make up the care of a child or vulnerable adult. Okay, let me rephrase that. 5064 would expand a good cause for a reason to quit when an employer has changed their hours for an employee, but the employee is unable to adjust to that change due to the care of a child or a vulnerable adult. ULP has also testified in support of SB 5193, which is the bill to train a pool of adjudicators so that they will be ready and available at hand in the event of an unemployment emergency. So it would resolve a number of the lack of resources and staffing issues that we faced in 2020. ULP is also proposing several additional changes to SB 5193 to improve the claims processing system. And we are fortunate and grateful to have an opportunity to provide input in this critical process. Washington State is now implementing the Continued Assistance Act, which extends the federal CARES programs of Pandemic Unemployment Assistance, the PUA, the Pandemic Extension of Unemployment Compensation, PEUC, and Pandemic Unemployment Compensation, PUC. This has been signed into law December 27th. The week of January 14th, ESD started paying the $300 a week Pandemic Unemployment Compensation. This was originally the $600 that was in existence from last March until the end of July. It is now $300 and it is extended for 11 weeks, ending March 13th. ESD has started to process an extra 11 weeks of pandemic extension of unemployment compensation payments starting the end of January. There are a little bit of complicated rules for how this fits into the claimant's benefit stream. As we get more clarity on this extension, we will provide them here and through our website. There is let me share it here, pull it up for you. There is a program progression chart. It's a PDF provided, I believe, by the Department of Labor. And we're also going to drop this link in our chat box that shows individuals who are regularly benefits eligible for unemployment compensation in Washington State. We recognize this as UI. And then the progression of how someone's benefits would be received and thus extended, and then also the impact of the pandemic extension and then the pandemic unemployment assistance. This chart, again, will be dropped into our link so you can take a further look at it. The American Rescue Plan proposed by President Biden would increase the weekly pandemic unemployment compensation from $300 to $400 and would pay it out through September. This has not yet been implemented. We are, of course, strong supporters for this plan, and we will certainly keep you posted as progress is made on the implementation, on the passing and hopefully implementation of this plan. That is all the updates that I have. I will turn it over to John for some comments before we move over to questions.
Yes, I've had quite a few inquiries since the resignation of the commissioner regarding how this will impact claimants. And the short answer is, I don't know yet. It's an opportunity for Governor Inslee to appoint a successor who can come up with a more client-focused, access-oriented program. While Ms. Levine was open to some reform to rules, what was sorely needed since last March was a better administration of the program, because thousands of claims were delayed and many are still not resolved right now. And so I would encourage anyone who's interested, if they wanted to write to a governor, to encourage him to appoint someone to the position who would focus more on client access, meaning hiring more people to answer the 800 number, hiring people to work on language access for people with English as a second language, to improve the website to make it more accessible, and to provide access for people who don't have access to internet. We've been pushing for years to have them reopen in-person claims, that a person could apply in person at a work source office. They haven't done that or made that available for years. After the pandemic, that would be a great idea for people who have trouble navigating the claims process, people have trouble working with the website, and for people with English as a second language. So that kind of advocacy would be helpful. So we will report in future meetings what we learn in terms of who is appointed. Of course, ULP will be working with whoever is appointed to improve our system. And also had questions about whether this resignation affects our court case in Olympia. Last June, the Sheridan Law Firm filed a petition for a writ of mandamus to ask the court at the Supreme Court to order ESD to process claims and make payments in a timely manner under the law. Fortunately, the court sent it to Thurston County Superior Court for more fact-finding. So that will go on for quite a while. I don't see currently any end date in sight on that, but the case will continue and is in the discovery process right now.
Great. Thank you, John. There are no questions in the Q&A box. So okay, one has popped up. Please share your questions here. We are here to answer. All right, here's a question. It sounds like the reason to quit for caring for someone would not cover parents of young children because they would not be able to work from home or would not be seeking work at home because they have to watch their children. Is this correct? And it would only cover people if their hours changed, not if their hours were the same, but the childcare's hours changed or closed. If passed, would this be retroactive for last year? I have some thoughts. John, do you-
I'll get us started. As far as retroactivity go, in general, I've rarely seen uh, anything made retroactive. Um, I, I I can't answer the specifics in terms of the details, but the issue that we're getting towards is right now the quit statute is very limited to good cause reasons, whether it be safety or pay cuts or things like that. So this would open up uh, another area where employers do change schedules that make finding childcare impossible. Um, if hours are changed, it would still be covered under if there's a 25% reduction in hours. Of course, many people's individual claims are very complicated and may involve more than one good cause reason for quitting.
Great. I would say, John, that caring for someone, so the question is, it would not cover parents of young children because they would not be able to work from home. My guess is that that would be correct because unemployment insurance is in its current state and most likely its future state designed to provide income for unemployed workers who are able and available and seeking work. If someone is unable or unavailable to work outside the home or in the home, then traditional UI would not be suitable or is not created for this type of situation. I think in this instance, PUA is created. And I'm not certain if this law change is looking to incorporate some of the aspects of PUA into UI. That might be the case. However, my guess would be it would be severely limited, given that it is supposed to be a temporary income source for people until they can seek work, not necessarily until their children are either school age or back into daycare. So I think there's going to be, we'll have to wait a little bit longer to find out what the impacts and what the exact scope and parameters would be of this proposed legislation.
And the whole pandemic issues have been an overlay. This would be a reform of the regular law under regular benefits that require a person to be able and available and actively searching. However, with the pandemic, we have, as Vanessa said, the pandemic, which would cover people who can't work due to childcare related to COVID issues, but also the job search now is currently on hold, which makes everything, more complicated at the moment. But we're looking for longer term reform because ULP has seen over the years this childcare issue been a barrier to unemployment benefits for many, many years. It's because a lot of it comes from the fact that when the unemployment system was established many years ago, it presumed automatically that the wage earner in the household would be probably the father and the children would be cared for by the mother at home. And that was never really what the situation was like, because mothers have been working forever, long before unemployment insurance. But it was more of a presumption that a person was available 24 hours a day, because if they did have children, it wasn't their responsibility to provide care. And that presumption we've found repeatedly to be incorrect. So this would do a lot to modernize the system for the coming years.
I completely agree with that, John. Thank you. Does the program progression chart include PUA, and can it be found online to be read? I would say yes. So I'm sharing my screen. I hope everyone can see it. The program progression chart on the bottom right-hand side does address PUA, and we have dropped the link into our chat for where you can find the PDF online. Hopefully everyone can see that. Next question is it correct that I should continue to apply for benefits even if that week's wages exceed my allowed benefit amount, but work for the next week is still not established?
Yes, because there's a problem sometimes. I've talked to people who don't claim, they feel, well, I'm not going to claim this week. I've been told that you can not claim a week and then come back, but I've also talked to people who, when they stopped claiming when they were working a temp job, had trouble then reopening and claiming again. They had to go through some hoops to get it open. So my advice, I think it's safe advice, because it's a very simple solution, is to make the claim. So if your unemployment claim was going to be $500 a week and you made $800 that week, and there's no way you will get any unemployment benefits, it's still good to file, answer the questions, and then when they ask you the question, did you work, you say yes, and then you give that amount. That way your claim will be open and consistent. So when you go to claim the next week, because you may not work at all the next week, it's less likely you'll have trouble getting into it. But if you don't claim, and let's say that temp job turns into 3 or 4 weeks, and you haven't claimed in 3 or 4 weeks, and then you try to go back and claim, it may give you a message that your claim was closed, and then you have to go through reopening it, and that sounds like a headache. So since claiming would only take a couple minutes, it would be worth it.
Great, thank you, John. Also, just to note, if you don't claim for 5 weeks or longer, you will need to restart your claim once you do sign back on after 5 weeks. So in order to not have that hurdle, I would follow John's advice and maybe just keep claiming consistently through the weeks. Looks like we have a participant who was finally able to get a hold of someone good at ESD and has scheduled a phone meeting with the ESD support. They don't want to lose their opportunity to have this individual's undivided attention. Is there any general advice we can give that they can explore with ESD while they have them on the phone?
Well, I mean, I guess I'm saying, if you get ready for a meeting like this, it's hard to sometimes, when you finally talk to the person, remember everything. I would make a list of everything you want to talk about. I would make sure that you're available a few minutes before the time, because it may end up starting a bit early, or it may start late, to be flexible with it. But I think one thing that I've talked to a lot of people, one thing that comes to mind is that sometimes people think everything's fine with their claim, or maybe they're working on one particular issue of overpayment, and they're not aware that there might be other problems. Like maybe they have an overpayment for 2 weeks, but in the system it says they have an overpayment for other weeks that they're not aware of. So or a denial for another reason, and maybe they've already requested a hearing, but it's really only going to be a hearing on that one issue, but not other issues. So it might be an opportunity, if you have the person on the line and they have full access to you, to your account, to ask them, how are things? Do you see any notices or anything in there that I should be responding to? That might be helpful at that time.
Great, thank you. Is Washington State participating in the extra $100 PUA for self-employed? If so, will the extra benefit be automatically added to one's weekly benefit, or does one have to apply for the extra $100 benefit? I am not certain of the answer, but I did just drop a link to the ESD CARES Act update alerts page, which might have some information there. John, do you know the answer?
No, honestly, no. It's a new issue for me.
Okay, I would say that traditionally, if there is an additional benefit or if benefits have changed, they are automatically added. claimants don't need to have to reapply. In terms of retroactivity, it's uncertain, though that might be decided on a case-by-case basis. But normally when there's a change to a benefit amount, ESD does automatically include that in its weekly payments. However, there may be a delay and we're uncertain on retroactivity. But as we find more information on that, we will provide it certainly next week at the webinar. If we have that, I'll give an update. All right, what advice would you give to those of us who haven't been paid anything and are still claiming? Where do we find help? It's been impossible to talk to anyone and it's been almost 6 months.
Well, some people have gotten help if they contact their state senator and state representative. There's a legislative on the Washington State Legislature website. You can find your district. Now, I've heard different things from different people, so I can't guarantee that contacting them will solve the problem. But I've heard back from many people who said that their senator or representative was able to contact ESD and get things moving or get things resolved, or at least find out what was going on or set up a meeting or something. Outcomes can be different. Now, each legislative district in Washington State has one senator and two representatives. I imagine they have a different view or different staffing. And so I would contact all three. Also contacting the governor's office, both by phone and by email. The governor's website has that. I've heard mixed results on that as well. Also, you can contact the Unemployment Law Project. We may be able to attempt to make a contact, but the results have been very, very mixed on that. The important thing is to read your notices very carefully and to look for any notice that has in the language there, you have a right to an appeal, and follow those instructions. If you find that late, just, you're discovering that maybe 2 months ago they sent you something and you never got it, but now you finally got it, still file the appeal, because they will consider a good reason for filing the appeal late. But you can also contact our office, Unemployment Law Project. But contacting the senators, representatives, and the governor's office is good for two reasons. One, of course, it may resolve your case quicker than it would have, but it also lets them know that the system does need to be reformed so that a person like yourself could just call the 800 number. And even if you have to wait a few minutes, you would be able to talk to a person who could answer your question and either resolve it in your favor or let you know why. If there is a barrier to your benefits, maybe there is. It's always possible there is some reason why they're being denied according to the rules, but you don't know that now, and it's just waiting and waiting. So making those contacts would be useful. And if there's no response, I would wait a week and try it one more time.
Excellent advice, John. I would affirm all of those suggestions. And I would also add that I have dropped in the chat box the Washington State District Finder and contact information for Governor Inslee's office, as well as the contact page for the Unemployment Law Project. So those resources are available. I would also say, I would encourage you to go back into your e-services account and reread all of the communications ESD has sent. Oftentimes they will ask for additional information. And when claimants fail to provide that information in what we believe is a relatively short turnaround time, ESD makes the summary determination to deny benefits. And then there's a halt on your payments. Sometimes if you have the opportunity to find out what they were asking, you could provide that information. As John suggests, you might be able to have your issues re-adjudicated right there through ESD and not have to go to a hearing for an appeal. Also, as John suggested, if you do see any notice that's denying you benefits for any reason, you do want to appeal and request a hearing, because that is going to give you further due process and an opportunity to receive your benefits. So take a look at your e-services account thoroughly. And also, people have been having a better opportunity to speak with a live person at ESD. We hear that first thing in the morning or closer to the end of the day, People are having better success. Try not to call on Monday morning since everyone else is, but throughout the week and throughout the days, if you have the patience and tolerance, which I would say it's worth it, try to get someone on ESD at the phone, someone at ESD on the phone.
And also, just as a footnote, when you do get that hearing, if you are denied and you do request the hearing, get a hearing, contact our office for help.
Great, absolutely. Okay, we have a participant who understands that hearing dates are currently set for months out. They sent in their appeal on December 5th by fax and by mail, and they have yet to hear from the department for a hearing date. While no news could be good news and they're in no hurry, should they just continue to be patient?
Well, I would be patient, but also you could call the Office of Hearings in Spokane. They have an 800 number that's at the Office of Administrative Hearings. I believe it's 800-366-0955, and just see if they have more information on the scheduling. That way you can maybe get a better idea of when it will be scheduled. And in fact, if it was received. Last year, the department decided to not send hearing requests over to the hearing office for months, which has led to some of the backlogs and delays. So I would, that way they could confirm that at least they have it in their queue, because if there's always a chance when you file a hearing request that the request becomes lost. This comes up occasionally. A person sends it by fax, they have a fax confirmation, and then later the department doesn't seem to have received it for whatever technical reason. So, it's good to confirm, because there can be a flaw in the communication of the hearing request.
That's great. I dropped the link for the Office of Administrative Hearings website. I will say they are very responsive on the telephone, in contrast to ESD, and they are also quite helpful and very informative. So I encourage you to call them. Also know that, yes, appeals are taking 3 to 4 months to be assigned a hearing date. And it is taking ESD approximately 2 to maybe 4 weeks to send a claimant's case over to OAH. And until OAH receives the claimant's files from ESD, they cannot assign a docket number. So call OAH, and you may have to check in with them every week or two to see if they have received your information and assigned you a docket number. Once you have a docket number and you would like free legal advice and assistance and representation from the Unemployment Law Project, contact our office. We will do an intake with you to assess your case and also assign you an attorney once you have your notice of hearing.
And, one other thing I just thought of with the long delay, people sometimes will move. And this has always been an issue for years, that you might change your address with the post office or change your address with ESD, but the hearing office might have the address that you had when you filed for your hearing request. So if you do move, you can contact the hearing office to update your mailing, your current mailing address, because again, if it's going to be 2 or 3 or 4 months away, there can be changes, and it would be a shame for them to send you a hearing notice that goes to your old address that is either not forwarded or forwarded too late.
Great, thank you. Okay, we have a participant who's just joining us here late, and they're wondering, are there 2 different ways to communicate with ESD? What does SAW stand for? And is there any different way to communicate with ESD rather than just sending them a message?
I believe SAW stands for, I think, Secure Access Washington. Is that okay? Well, yeah, that's the main way. Of course, there's the 800 number. They don't have in person. I mean, even before the pandemic, they don't have like an in-person way you can just go into an office and talk to a person. So if it's a matter of not getting access, I'll repeat what I said earlier. It's good to contact your state senator, your state representative. We have the contact information for the legislature in the chat, for the governor's office, by email and phone. That sometimes can lead to access if you simply cannot get through on the phone, or if they're not responding to messages on your account.
Right, thank you. So I would say John is correct. SAW stands for Secure Access Washington, and that is an interchangeable term with e-services. So you'll hear both of those terms, and both of those refer to your online account with the Employment Security Department. You can send a message to ESD through your e-services or SAW account. However, we have been told that they are understaffed and under-resourced to respond to messages. I do still advise claimants to send the message because it is a form of documentation, and it's another opportunity to attempt to receive communication, to communicate with ESD. You do not want to file your appeal through a message. There are prescribed ways to file an appeal if you've been denied, and that's listed on your denial letter, the different ways to access your appeal rights. So rather than just sending a message, there are certain protocols that you need to follow for your appeal.
And also, as far as filing an appeal goes, some people will file their appeal more than one way: fax and mail, or e-services and fax or mail. There's no harm in doing that. And if there would be an error through one of the systems, that would be a backup.
Great. Okay. We have a, let's see. Okay, we have a participant who is a substitute professional. They had spent a few days substituting during the week of January 11th. They filed a claim, including the 2 days that they worked, and received a reduced payment. When they were going to claim their benefits for last week, they will have to answer that the last day they worked for the district and why they're not working for them anymore. They're unsure which reason to provide, since none apply directly to their situation. The closest answer could be laid off, but that's not entirely accurate because the sub job wasn't available. We've heard this before. Possible answers include laid off, leave of absence, quit, strike, suspended, temporarily out of work due to attend mandatory apprenticeship training. They did not have any substitute days during the week that they are claiming, which is probably why the questions had popped up. What do we recommend in terms of what they choose for the reason for not working?
This is probably, I think, lack of work or layoff fits best, because a person can be connected to an employer. Let's say a person worked for a temp agency and they're on the books. So they're not fired, they're not quitting, they're not being laid off from ever working for them again. But that particular assignment has ended. So, it's not a quit, it's not a firing of any kind. So that's probably the best answer you can come up with.
Great, I would agree. Okay. That is all the questions we have for right now. So we will wait a couple more minutes to see if any additional questions pop up. Feel free to share your questions in the Q&A box. I want to thank everyone for participating today. We'll wait just another minute or so. If any of your questions have not been answered or they come to you after the webinar, do reach out to our office. Our contact information is provided in the chat box. We are here to help you today and throughout the week. Okay, we have a participant who's saying that John spoke of 3 ways to contact ESD. What was number 3?
Well, the phone, I believe I was talking about, calling the 800 number, using the e-services or sock count or attempting to use a representative or a senator, to intervene or gain access.
Great. Okay, not seeing any more. Oh, I'm sorry, one more. I'm not sure that lack of work is an option. I believe this was the earlier question. Which, John, would you presume that lack of work and laid off to be interchangeable in this instance?
For the purposes of unemployment, yes. And unfortunately, they don't have other options. It's something that needs to change. But yeah, that's best, because lack of work and layoff, in the sense that what they're looking at is the fact that there's not that the reason the work ended is not because of your choice. Okay, so you're not quitting, and it's not due to a bad reason, like being fired for alleged, terrible behavior or something like that. So there's no fault and there's no harm, there's nothing like that. It's simply that particular assignment only went so many days or so many hours. So that's the best. In spite of the fact that a large number of people in the economy work for temp agencies or have jobs that are kind of on call, whether it be a substitute teacher or even I've talked to people in the medical profession who work on call jobs, they still don't have categories to clearly accommodate that. But clearly you were not fired. Clearly you did not quit. So that's still your best option there.
All right, that's all for this week. We will wrap up. I'd like to thank John for his answers and participation. I'd like to thank Aaron for assistance on the back end. We look forward to having Ann join us next week. We thank you all for your thoughtful questions and for helping us perform the work we do. We wish you a great week, and we'll look forward to seeing you next Monday at noon. Bye, everyone.
Thank you.